Did you know that the United States Constitution gives you the same rights, bundle of rights that you get in your real property, like your house, and personal property, like your car? You get those same rights in your intellectual property, meaning the same rights in things like your trademarks, patents, copyright, and trade secret. And I say that to say that the United States, our government, thinks it's that valuable that they enumerated it into the Constitution. But oftentimes people don't understand what intellectual property is in order to truly take advantage of that. We all know how to get a house, we know how to get a car, but how about your intellectual property? So today's seminar is about safeguarding your intellectual property, and we're going to go through each type very broadly, and teach you how to take advantage of that and how to monetize it. We're going to start with trademarks, but we're going to start with a quick pop quiz. True or false, you can trademark a color, sound, and or fragrance. For those of you who think that's true, raise your hands. Wow, okay. And for everyone else who believes that's false, I'm assuming your hand was down. The correct answer is it is true. A trademark is not just a logo, it's not just a catchphrase. A trademark by definition is an indicator of the source of a good or service. So it's something that indicates the owner, or the source, of the good or service, okay? So for example, if you see a Nike check mark on some shoes, you're not thinking shoes, you're thinking Nike, the source of those shoes, right? The same way if you see it on a hat or on a hoodie or whatever, it's considered the source is Nike. So remember that it's an indicator of the source of a good. I'm gonna say that a few times because I think there's a lot of people who have a misconception to think it's just like a logo. To qualify for trademark protection, you have to meet two requirements. The first one is that your desired mark has to be unique or distinctive. And the second requirement is that it has to be used in commerce. Let's break it down. To meet the distinctiveness element of trademark protection, you can pick a mark that is inherently distinctive or one that acquires distinctiveness. A mark that's inherently distinctive, we have a few categories for those: fanciful, arbitrary, suggestive, but ultimately it's something made up, something that is unique, that is not already out there, that you just kind of make up. Some great examples for that are like the camel logo that's on a pack of cigarettes. What does an animal have to do with cigarettes? Not much, right? Or the apple fruit on my computer or your computers. They have nothing to do with each other, so those would be arbitrary. Or how about the word Kleenex for a box of tissues, or Q-tip for the little ear swab? Those are all very made up terms, and those would be inherently distinctive. Another category that I would not recommend you go into unless you're really tied to your brand already is acquired distinctiveness. And ultimately what acquired distinctiveness is it develops a secondary meaning in the mind of the public, where the primary significance of the mark is to identify the source of a product rather than the product itself. So eventually, the public starts to recognize that mark as the source of it. So they'll see your mark, and over time, they'll realize that you're the source of that mark, and then you'll go up in front of the USPTO and argue that your mark is distinctive because it acquired secondary meaning. Another way to do that is by having your mark on the secondary registrar for 5 years, and then it'll automatically acquire secondary, it'll acquire distinctiveness. So on the secondary registrar. You can try that, but that also opens you up to 5 years of someone else asserting their rights, and it is pretty risky. So this is why I say if you are in the beginning phases of your business, or you're capable of rebranding without disrupting your business too much, you want to stick to inherently distinctive. The second requirement, excuse me while I drink. The second requirement is that your mark is used in commerce. What you'll find often is that the US does not reward you for just having an idea. You have to do something with it. It's somewhat of like a utilitarian theory, right? Otherwise, you'll have a lot of people come up with ideas and sit on them and protect them and prevent others from actually doing something with them, which will ultimately just not be very effective for development and for progress in the US. So you actually have to use the mark. This is where use in commerce comes into play. If you have a use in commerce looks something like putting your mark on your tags and then actually offering your products for sale and selling them or shipping them. So it's not enough to just put your logo on your t-shirts and put those t-shirts in a box in your basement. You need to put those t-shirts, for example, on your website and have an area where someone can click add to cart and then they can go and check out. So you need to use it in commerce. But let's say that you are, in the development phase of your brand and you're working with a manufacturer and your shipment is coming in the next 3 months, so you need to protect your brand now. There is an application you can file with the USPTO called an intent to use application that gives you a little bit of time to do that. Basically, you're saying, I intend to use this in the very near future. And I should mention that's a separate application. Then you need to file a 1A, so then you're gonna have to do 2 applications and 2 application fees with the USPTO. So the main takeaway here I want you to understand is that 1, your mark has to be unique and distinctive. One way that we do that at the law firm is we do a clearance search. So we'll search all 50 states. It's not just the USPTO that you need to search. There are common law rights to trademarks, so you're also going to be searching things like Facebook, like social media, just the internet generally. So you want to do a search to see if there's anyone else using a similar mark. If not, you very well may be in the distinctive category, and then you want to actually use it in commerce. If you meet those 2 qualifications, your trademark is protected and you should go ahead and file with the USPTO. All right, pop quiz. Number 1, who believes that Velcro, Q-tip, and super glue are active marks? Raise your hand if you think they're active marks. All right. And 2, dry ice, trampoline, kerosene are active marks. Raise your hand if you believe they're active marks. No. Okay. Well, should I put you on the spot? Why do you think they're not active marks?
I guess when I see a trampoline boxed up, I don't see the little symbol by it saying it's trademarks, but that's just my guess.
Okay. Well, the correct answer for number 1 is true, but it's at risk at not being a trademark. It's at risk at not being active. And for number 2, it is not true. It used to be an active mark, but it lost its trademark protection, okay? So that brings us to the next point. Trademarks are not forever, right? They expire at some point, and here's how they expire. Number 1 is they become no longer distinctive. We said that's one of the requirements. So if your mark is no longer distinctive, it is no longer protectable under law, okay? And number 2 is you just abandon it. You say, I no longer want this mark, I don't need it, whatever. You abandon your mark. How does your mark lose its distinctiveness? One of the ways is through genericness or genericide, okay? This is when a term refers to a general class of products versus the source of the product, okay? So if I ask you to search something on the internet, what do I usually say? Just Google it. Google is a trademark, okay? If people start to refer to an internet search as Google or as Googling it, it becomes generic over time. A big one is Velcro, and I hope you'll all take time to search this YouTube video. This is the legal staff at Velcro, and they put together this entire song and dance pleading with the public to stop calling Velcro, because Velcro is actually called a hoop and loop. And they said, we have spent so much money and so much time protecting our brand, and you guys are risking us for losing that brand by making it generic, because now we all refer to a hoop and loop as Velcro. Did you guys know it was called hoop and loop? It's hoop and loop. And the same goes for All of these marks. The ones in number 2 have become generic and lost their trademark protection. The one in number 1 are at risk of losing their trademark protection. So those are the 2 ways. All right. That was a quick lesson on trademarks. We're moving on to copyright. I think copyright is super relevant right now with social media and having people just take a lot of photos, posting songs and captions to, get more traction on their photos. Well, all of that is copyrighted work, okay? So to know that, you'd have to understand what a copyright is. A copyright protects the expression of an idea. So I said earlier that the US does not reward you for just having an idea. You need to do something with it, okay? For a copyright to be protectable, you have to actually express your idea. And we're gonna talk about that. Here's the 2 requirements. The first requirement to qualify for copyright protection is that you have to have an original work. And an original work is just an independent work reflecting a modicum of creativity. Modicum basically means it has to be somewhat creative, like just a little bit creative. Okay, and it has to be an original work. And number 2, it has to be fixed in some kind of medium. So you need to put it down somewhere. You could potentially write it down. If you have an idea for a book, you can write it down on a piece of paper and start your book draft. If you have an idea for a sculpture, you can start, doing the plans, sculpting them out, or actually start building your sculpture. But you need to do something with it. So those are the 2 requirements. You have to have an original work that is somewhat creative, and number 2, it has to be fixed in some kind of fixed medium. True or false? Pop quiz. You can copyright someone else's work. Like let's say you hire someone and they do, they write something for you, like a ghostwriter. Can you copyright their work? For those who believe that's true, please raise your hands. 1, 2, 3. Got a maybe. Yes. So the answer is maybe, but mostly it's yes. It can be done through a work for hire arrangement where someone assigns their copyright to you through a contract. But if you do not have that present and you just try to copyright someone's work, you cannot do that. Most likely, when you're going through the copyright office, they're going to probably assert their claims, their right to it, and then stop you from being able to copyright it, or they could retroactively do it. One thing about copyright protection, which I believe is going to come up next, is that you don't have to register it, and there's no deadline to do so. Because if you were to register your copyright, for example, a photographer who takes hundreds of photos in one session, it's not very practical to require them to go and register 100 photos just so that they have protection, okay? But because they meet the 2 requirements we talked about, they have an original work, they're the author, it's unique, they created it, it's their work, and it's fixed in a photograph, they are automatically the copyright owner. Automatic, okay? What you need to do though is if you want to enforce your rights, then you have to register your photo in this example, okay? So let's say you realize someone is stealing your copyright or your intellectual property copyright, and you want to stop them, and you send a cease and desist, and they're not responsive, and now you need to take them to court and do something about it, then you can go with the Copyright Office and register your copyright, get your certificate, and then you can take them to court. What happens when you have registration? Well, it's these bundle of sticks that we talked about. It's the same things that you get when you own a house, like I said, or own a car, own a trademark. You have these exclusive rights that only you, as the copyright holder or IP owner, can do. You have the right to reproduce the work if you want to. Prepare derivatives like Rocky 1, Rocky 2, Rocky 3. Those are all derivatives. Distribute copies to the public, perform it publicly, display it publicly. Those are only rights that you have and no one else can do. There's a few exceptions to that, because you might be wondering, sometimes there's people who use other artists' songs as the background for their videos, or sometimes my teacher, she would copy a textbook and give me a chapter or two, right? There's certain situations. For example, do you remember when former President Obama was running and there was a photo of him that was recreated in blue and red that went viral? the guy who adjusted that photo wasn't the original photographer. So there's certain situations where works can be used by people who don't owe them, who are not the original authors. It gets pretty complicated, but it falls under the fair use exception, okay? So under the fair use exception, the fair use of a copyright work and its derivatives includes for purposes such as you can use someone else's work for criticism, comments, news reporting, teaching, scholarship, or research. That type of use is not considered an infringement. And you might be wondering, how long do I get to keep my copyright? Well, it's not forever, because another fair use is copyright that's already in the public domain. Copyright becomes in the public domain once it expires, and here's when it expires. It starts when the work is actually created, and it lasts for the life of the creator plus 70 years. Imagine, it's something you can actually devise in a will. Your heirs can get your intellectual property because it outlives you. So it's your life plus 70 years. If it's a work for hire arrangement, so let's say the company owns it, then it just lasts for 120 years because a company could live forever. Awesome, awesome. We're gonna take a 5-minute intermission to give a shout out to our vendors, and then we're gonna move on to our patent section. So as I stated when we first started, we really wanted to work with local small businesses. I mean, we work with small businesses. This is our passion, and we wanted to represent that in our events as well. So I wanted to recognize Something Sweet, Iralee Mendoza, who made all of the amazing desserts that you have here today. The Decor by Evelyn Cordova, all the beautiful decor that you see everywhere that just exceeds my expectation. It's beautiful. Photos by Malia Bernard, our wonderful photographer here today. We have did I mix up everyone's name? Wait, did I mix up everyone's name?
Something Tranquilo would be for the sweets, for the drinks, and that's Iralee Mendoza. And then for the sweets and treats, that's Emma Banks right there, and then Malia Bernard for the photos. Evelyn for the decor, no, but everything's great.
I'm so sorry, I messed up everyone's name. And then we have our videographers here today. We have Jordan and Ethan. And Jordan, it's not Diverse Network, right?
Executive creators.
Executive creators. Okay, next time I'll get this better. Also, quick shout out to Carlos Rodriguez from Underworld Feast. They provided their salsa here today, and they're in a lot of local stores here in Columbus. Amazing salsa and so many flavors. Please have some, and if you dare, have the really spicy one. All right. Yeah, let's give them a round of applause. Yeah, thank you. All right. True or false? Patent protection is global. And I mean, if I protect something in the US, it's covered all over the world. True? Raise your hand. True. Anyone else? The answer is false. I wish it was true, but it's actually false. It's the same with trademarks and copyright, believe it or not. Every country out there has their own intellectual property registration system. The United States, obviously we're very familiar with that. It's through the United States Patent and Trademark Office and through the Copyright Office. However, every country has a separate one. China has their own. This is why a lot of the times people will patent things, let's say in the US, and then you'll see a lot of dupes coming out in China, for example. One of the most comprehensive ones is through the European Union, but nonetheless, every country has their own. So keep that in mind. All right, there are 3 types of patents that you can get. At the firm, we partner with patent attorneys to help our clients protect their patents. You can do it yourself, or you can work with a patent certified attorney, and not all attorneys can do patent law. There's 3 types. 1, there's plant patents. 2, design, and 3, utility. Today I'm just going to talk about utility. It's the most popular one. To be patentable, the invention or creation described has to meet these requirements. 1, it has to be novel. which means it has to include a combination of features that have not been seen before. So it has to be unique and new, just like the distinctiveness requirement. 2, it has to be useful. If it's not useful, it's probably copyright world, right? It might just be more of an art if there's no use for it. 3, it can't be obvious, so non-obvious, as in it cannot obviously flow from something that's already patented out there. So non-obvious. And 3, it cannot be published. This is huge. It cannot be published, which means you cannot tell people about it. If you want to be able to patent something, you cannot tell people about it. Let me touch on that one more time. You cannot tell people about it. This is huge. If you have an idea that might be unique that you can go and share with, that's something unique that you know you can patent because it meets those requirements that we just discussed. Okay. And then you go and tell all your friends and family because you want to get their opinion on it. You are at risk of having published your patent, so when you go and try to register with the USPTO, they're going to deny you patent registration, so you have to keep it confidential. One of the segments we might do is on secrecy agreements, things like NDA and confidentiality agreements, and that's a great way to be able to talk about your patent. But just remember that it cannot be published. Okay, there's 2 types of patent applications that you can do. One is provisional, which is like a placeholder. It gives you 1 year to talk to people about your patent without risk of having it being published and non-patentable. So you have 1 year. It allows you to establish a date of invention. It allows you to disclose the invention, and it expires after 1 year. So 365 days, on day 366, it expires and it becomes public. So you need to, within that year, transfer it into a non-provisional. Non-provisional is the patent of all patents. This is where we all want to be. Non-provisional is the real deal. It takes a while to register. It can be from months to decades. A lot of patents out there are quite complex with a lot of technicalities and terms and drawings that need to go into them. So they can take quite a bit of time. It does expire, unfortunately. Your patent protection starts from when you file and up to 21 years. After 21 years, your patent goes into the public domain and people can start creating dupes at that point. It's that's what I just said. It's non-renewable. It goes into the public domain. And of course, it's only enforceable in the US, not abroad. Each country has their own patent office. And the last one is one that I actually don't hear many people talking about, but I think is spectacular. It's trade secret. Trade secret is actually not, it's not something you register, and it's not something that's granted to you through the US Constitution. In fact, trade secret is contractual. Contracts have so much power, you guys. At GK Laco, we love contracts. I don't know about you guys, but we do. Because contracts can help you protect your intellectual property past expiration of intellectual property that you register. A patent expires after 21 years. A trade secret stays until it becomes public. The only requirement is that it stays a secret. As long as you keep it a secret within your organization, it's protectable and it stays protected. So the question is, why would you choose something like a trade secret over patent protection? Anybody? Because patents sound great, right? But does anyone know?
Does it not expire? Well, you said it doesn't expire.
And someone's paying attention. That's my sister, everyone. Yes. That's right. You know, trade secret protection, like I said, it's very valuable because, one, it doesn't expire so long as it stays a secret. And also, number 2 is it's cheaper than a patent. You can get this protection a lot quicker than a patent. Before we move on to this point, I want to show you this awesome example that we have, Coca-Cola. Did you know that Coca-Cola never patented their formula to make the amazing Coca-Cola that we all love and enjoy? They never patented. They instead chose to protect it through trade secret. The way that they do that is like this. This is a major corporation with hundreds of employees. And what they've done is created a very curated system where only half of the leaders or members of the corporation have access to half of the formula. The other half have access to the other half. They have check-in and check-out logs as people, access certain documents and disclosures. They have everyone bound by secrecy through agreements, and they keep this up and have kept it up for decades. So they decided not to patent, because if Coca-Cola patented their formula for their amazing drinks, then at this point, it's been past 21 years that they've been in business, it would have been public, and everyone else would know their formula, and we would all be able to duplicate the Coca-Cola recipe. So I say that just to say that it's not just for small companies. These are mega corporations that are taking advantage of trade secret, and it is powerful and impactful. Yeah.
So it's like a trade secret, like a formal NDA almost?
It's a contractual agreement, yes. Exactly. But just imagine, people breach contracts all the time. So one of the best things to do is just not give one person full access to the entire recipe, But yes, it is contractual. All right, so in the very beginning, I shared that intellectual property has a lot of value, and I mean monetary value, again, in the same way that your real property and personal property would have value. Here's how you can monetize it. One, and super big right now in social media world, is through your branding. You can create a brand that no one can replicate, and if they tried, you can send them a cease and desist and stop them from infringing on your brand. But instead of sending a cease and desist and suing them, you might then want to have another revenue stream and just have them license the right to use your brand. And say, okay, you can use a name that's similar to mine, not identical but similar, but you have to pay me a small fee every month. So licensing is another way that you can monetize it. And the last way is that you can increase your company valuation, right? So if you're out there trying to value your money or your company for whatever reason, let's say you're out there seeking funds and you want to have a valuation to your company, you can include your intellectual property as part of that. I'll leave you with a couple tips from an IP attorney. That is me. Hello. Here are a couple ways for you not to lose money. So we told you how you can make money and how to protect your IP. Now here's how you don't lose your money. Number one is my copyright alert here. Never assume that what you see in the marketplace, in the media, or on the internet is in the public domain and free to copy, download, and use. Never assume that, okay? Number two is always get legal clearance if you're not sure. If you don't know whether it's protected by intellectual property and you see something online, try to figure out who owns it and ask them for permission to use it. And number three, always bring suspected infringement of your business IP to the attention of legal department, or take care of it yourself. If you see people that are using your intellectual property, the standard is if they're using it in a way that confuses consumers, that makes them believe that that person is you. If you see something like that, then do something about it and don't just sit on your rights, okay? Awesome, that's it. Now it's Q&A time. Does anyone have any questions about our IP segment? Thank you so much. Okay guys, if you don't have any questions, oh, I have a question in the back. Okay, Tasha.
About how long does it take for a trademark application to be processed?
That's a great question, Tasha Love. So trademark applications actually used to take about 8 months, but since COVID, there were an influx of new businesses started in 2020 and an influx of USPTO applications that now it's taking them 18 months to just assign an examiner to review your application. So it'll take 2 years, around 2 years. But what I hope you took away from this presentation as well is that you don't have to register your intellectual property to have it protected, so long as you meet the requirements that we talked about. If you have specific questions about your trademark is geographical, then feel free to reach out to me and I can help you navigate through that. Good question. Yes, Carlos.
So when you register for a trademark, you can start using TM with intent to use. And then after it's approved approved, then you can start using PR for registered?
With the circle, you got it, exactly. If
TM no circle?
TM no circle, exactly. If you guys heard that, before you register, so there's two parts. When you have the intent to use application or when you have trademark rights because you meet those requirements, you can use the TM abbreviations trademark next to your desired mark. When it's actually registered with the USPTO, then you can officially use the R with the circle. For copyright, as long as you meet the requirements we talk about, I told you you don't have to register your copyright. As long as you meet those requirements, you should and can start putting the R with the circle around it next to your copyrighted materials, just to put everyone else on notice.
I wanted to touch on something. In the beginning of the presentation, you talked about involving an attorney before, like not just when you're getting ready to sue. And so I kind of want to revisit that. What are the benefits of I can go online, I can Google it.
Yeah.
So like, what are the benefits? I wanted to circle back to that.
Yeah, great question, great question. Okay, so here's the thing. A lot of the times we have people come to us for trademark applications and they will say, no, I know it's good to use. I've already looked online. I know it's good to use. And I ask, where have you looked? And you look on Google. Most of the time they're checking the uspto.gov website. That is fantastic because what the .gov website shows you is registered marks or intent to use marks. But trademark protection is not just for registered marks. There's common law protection in all 50 states. What I mean by that is if you meet the requirements for trademark protection and you're starting to use it, whatever geographic area you're using it in, you have the senior right to it there. However, when someone registers it, they have the right everywhere else, okay? So USPTO registration is the superior one. So anyways, there's common law rights. What your attorney will do and what we're trained to do is a comprehensive search that looks into all 50 states in addition to the USPTO. We look at federal, state, counties, we look at social media. We do a super in-depth search and then we provide you with a clearance opinion letter that tells you whether we think you have a good chance of getting that mark registered or not. If we say you don't, we're saving you a lot of time, money, and heartache because we're stopping you from having to go through a cease and desist process with someone else trying to assert their rights because you're infringing on their mark, or stopping you from having to deal with a lot of office action through the USPTO, which is basically them pushing back on your registration. Good question. You're welcome. Any other questions? All right, if you guys have questions, I will leave you right here with our contact information. Please feel free to reach out. We would appreciate if you can give us a follow on our social medias. Our handle's right here, GK Law Co. And then this is a QR code. We'll keep this up for the rest of the evening if you don't mind scanning. This is a quick survey. We'd like to just, get to know you a little bit better and see if you had fun at this event and what other topics you'd like for us to discuss next time in January. All right. Thank you all.